Thank you all for joining us today. I'm Josie Martinez, Senior Partner and General Counsel for EBS Insurance Brokers. We have a fabulous turnout today, given the fact that Mass Pfml is fast approaching, and many people have questions on how it will impact them. EBS had its first webinar, as you may recall, on Mass Pfml last year, and has been working very hard to stay current with the latest developments and answer client questions as they have come up. Looking ahead, we knew this was going to be a big issue for our clients as we approach January 1st. To be fully prepared and in a great position to answer client questions and requests, we decided to add a full-time resource to our team to be a guru on all things Mass Pfml. We're happy to introduce you all to Lindsey Ross, EBS's Director of Leave Management. Lindsey will be EBS's subject matter expert on leave management. As leave regulations become more complex, we felt we needed a resource to help clients with any questions or needs they have with leave management. Lindsey will be presenting the material today and answering questions you have at the end of her presentation. I am now going to turn it over to Lindsey. Enjoy and good luck.
Thanks, Josie. Hi, everyone. I'm Lindsey Ross. I'm the Director of Leave Management at EBS. Once things go back to normal, I hope to have the opportunity to meet all of you in person, but in the meantime, please feel free to reach out to me virtually, whether it's to discuss employee leaves or just say hi. As a reminder, please submit your questions throughout today's webinar in the chat box in the bottom right corner. We'll review the questions at the end, and I'll answer as many as I can. If there are any that we're not able to get to today, we will include a full question and answer in the follow-up communications, along with a recording of the webinar. All right, I know you guys are excited to talk about Mass Pfml, so let's get started. Our team at EBS wants to provide you with the latest updates as Mass Pfml is quickly approaching and the department released the final regulations over the summer. While we're still waiting on some information from the state, you can see that we have a lot of new content that we're going to cover today. But before we jump into what's new, let's do a quick recap of the leave benefits under Mass Pfml that begin on January 1st, 2021. As I'm sure you all know by now, beginning January 2021, covered individuals will be eligible for up to 26 weeks of leave total. The aggregate leave amount may consist of some combination of medical leave and family leave. Beginning on January 1st, 2021, covered individuals will be eligible for up to 20 weeks of medical leave within a benefit year for their own serious health condition. Also beginning January 1st, 2021, covered individuals will be eligible for up to 12 weeks of family leave for the birth, adoption, or foster care placement of a child, up to 12 weeks of family leave due to a qualifying exigency arising out of the fact that a family member is on active duty or has been notified of an impending call to active duty, and up to 26 weeks of family leave to care for a family member who is a covered service member. Then, if we fast forward to July 1st, 2021, that is the date that a covered individual will be eligible for up to 12 weeks of family leave to care for a family member with a serious health condition. Just a quick reminder, the benefit year is the 52-week period beginning on the Sunday preceding the first day of leave taken, rolling forward. Leave allotments are based on the number of hours or days a covered individual works. If the individual works a part-time schedule or variable hours, the amount of leave will be proportional to the amount of time that the employee normally works. All right, let's dive into intermittent leave. So, when exactly does intermittent leave apply? Well, it varies depending on the type of leave being taken. If an employee is taking medical leave for their own serious health condition, they can take leave intermittently only if it's medically necessary. If an employee is taking family leave to care for a family member's serious health condition or to care for a covered service member, they can take intermittent leave only if medically necessary. If an employee is taking family leave to bond with a child, they can take leave intermittently only if the employer and the employee agree. And if the employee is taking family leave due to a qualifying exigency, they can take leave intermittently. The employee will need to verify the hours taken each week with the department. An intermittent leave can be taken in increments consistent with the employer's policy for other types of leave. However, the minimum increment will be 15 minutes. Employees must also follow the standard call-in procedures of the employer for intermittent leave. there is an initial 7 calendar day waiting period before benefits will be payable. This waiting period does count against the 26 weeks each employee has of available leave in the benefit year. If the leave is intermittent, the waiting period will be 7 consecutive calendar days from the first instance of leave. The employee will not need to accumulate 7 days of leave before the benefits will be payable. This waiting period applies with each and every application for benefits. The only exception to this is when medical leave and family leave are both taken when a baby is born. The 7-day wait period will apply for the medical leave, but there will be no wait period applied to the family baby bonding leave that follows the medical leave, as long as the healthcare provider documents that family leave will be taken immediately after the medical leave. I hope that all made sense, but if you still have questions, please send them through the chat box. Now let's talk about the weekly benefit amounts. For those of us that aren't great at math, this part can be a little tricky. The weekly benefit amount for covered individuals is calculated based on the individual's average weekly wage at the time of requesting leave compared to the state's average weekly wage. The maximum benefit will be $850 per week for 2021, but that is subject to change annually. It will be reviewed each October, and the new average weekly wage will start on January of the next year. The weekly benefit amount is calculated at 80% of the employee's average weekly wage up to 50% of the state's average weekly wage. Anything over 50% of the state's average weekly wage will be paid at between 50% and 80% of the employee's average weekly wage, up to the $850 maximum. I know that can be a little overwhelming, but the state has provided the next breakdown that I think makes it a little bit easier to understand. The average weekly wage in 2019 was $1,431.66. 50% of that is $715.83. If your average weekly wage is less than or equal to $715 a week, you will receive 80% of your average weekly wage. If your average weekly wage is more than $750 per week, you will receive between 50% and 80% of your average weekly wage, up to $850. There is a helpful calculator on the mass.gov website in order to calculate expected wages. I would highly recommend checking that out because it makes it a lot easier than trying to figure it out with these numbers that they've provided. There are a few things or situations that may reduce the weekly benefit payment an employee receives from the state. The amount an employee receives may be reduced by wages or any wage replacement an employee receives during this time from a government program such as unemployment or workers' compensation. If an employee is receiving either unemployment or workers' compensation, this would reduce the amount of the payment that they receive. Benefits may also be reduced by a paid family or medical leave benefit from any source, including the employer, for a qualifying reason during the prior 12 months. However, any leave taken by the covered individual for the same qualifying reason before January 1st, 2021 won't count against the covered individual's weekly benefit amount and or leave allotment in 2021. Benefits will not be reduced by a long-term disability policy of the employer or permanent partial disability incurred before the application for benefits, such as a Social Security benefit. What if an employee uses accrued paid leave rather than apply for a mass Pfml benefit? If an employee uses accrued paid leave or leave through an extended illness leave bank instead of applying for benefits through mass Pfml, the employee will not receive payments from the department during this time. Any accrued paid leave or leave through an extended illness leave bank would run concurrently with any leave available under mass Pfml. Employers must inform employees who choose to use accrued paid leave or leave from an extended illness leave program that the use of these leave accruals will run concurrently with the leave period available to them from the mass Pfml program. Employers must report the use of accrued leave to the department if requested. Okay, let's talk about if and when employers are reimbursed for employee leaves. What if an employer makes payments that mirror Mass Pfml and are equal to or greater than the Mass Pfml benefits? In this case, the employer can file for reimbursement. If an employer has a policy such as an STD program or a maternity or family leave policy and makes payments to an employee that are equal to or greater than what would be paid by Mass Pfml, the employer may be reimbursed by the department. Employers will not be eligible for reimbursement if the employee chose to use accrued paid leave in lieu of applying for Mass Pfml, even if the PTO is taken just to supplement an STD benefit or family leave benefit from the employer. Remember, the use of PTO for a qualifying reason will run concurrently with Mass Pfml, and employers must report the use of accrued paid leave to the department. Employers will not be eligible for reimbursement if the employee received benefits from the department for the same time period. And of course, employers would only be entitled to reimbursement if they are participating in the state plan. Employers can't apply for reimbursement if the employer has received an approval for a private plan exemption. In order to receive the reimbursement, the employers will need to provide evidence of payments to the employee. One very big question most people still have around Mass Pfml is likely, how does an employee apply for benefits through the state, and what does that process look like? While the department has not provided the forms to be used to apply for the benefits yet, they have provided some guidance on how the application process will go. The first step will be the employee notifying the employer of the need for leave. This will need to be done before the employee completes an application. Once the employer has been notified, the employee can apply for leave through the department. The department will have 14 days after receiving that application to notify the employer if the claim has been approved or denied, or if more information is needed. The department will send a notification to the employer within 5 days of receiving the application. The employer will have 10 days to respond to the request and provide supporting information to the department. If the claim is approved, benefits will begin 14 days later. The employee will need to notify the employer of the need for leave 30 to 60 days prior to the anticipated start date, or as soon as practical. Notice of the need for leave must be given to the employer prior to the application being filed with the department. The application will not be accepted unless notice has been given, and the department will ask for evidence that the notice was given to the employer. The employee must comply with the employer's usual notice and procedural requirements for requesting leave. State-issued forms must be used for the benefit applications, but these are still pending from the state. When planning medical treatment, the employee must consult with the employer in advance of an application to the department and make a reasonable effort to schedule the treatment so as not to disrupt unduly the employer's business operations, subject to the approval of the healthcare provider. What information will employees need to submit an application? While the department has not yet provided application forms, we do know what information the employee will need to provide on the application. This includes identifying information, including a social security number, whether the leave is for medical or family leave, the start date and expected duration of the leave, whether it's intermittent or continuous, the employer name and EIN number, evidence that notice was granted to the employer, any denied, granted, or pending requests for leave for a qualifying reason within the last 12 months, if applicable, an attestation regarding a family relationship if it's for family leave, consent for the department to share info with the employer or healthcare providers as needed to process the application, as well as a completed application form. The state may reduce the benefits the employee receives if the application does not include all of the required information and more than 90 calendar days have passed. As an employer, you're probably wondering, what will my responsibilities be, or what notifications will I receive? And of course, when? 5 days after an employee files an application for leave with the department, the state will notify the employer of the request in order to exchange information such as the type of leave requested, the expected duration of the leave, and whether it is continuous or intermittent leave. The department will also ask the employer whether the employee's request for leave from the employer had been approved, denied, or pended for additional information. Assuming the employer had approved the employee's request for leave, the employer has 10 days to provide supporting information to the department so the department can continue processing the application for benefits. The state will ask for wage and/or earnings for the past 12 months, a description of the employee's position, whether the employee works a full or part-time schedule, weekly hours worked, prior requests or approvals for a qualifying reason, amount of paid leave already taken for a qualifying reason during the current benefit year, a description of the employer's own paid leave policies and if the employee has received paid or unpaid leave during the last 12 months under any plan of the employer, and if they will receive any paid benefits from the employer during this leave, whether the employee has applied for concurrent Pfml or other leave and if it has been approved, whether the employee will be receiving any other wage replacement benefits, and any other relevant information or records relating to the claim, including any evidence of a potentially fraudulent claim. Within 14 calendar days of receiving the application, the state will notify the employee if their leave is approved, denied, or additional information is needed. What happens if the employee's leave is approved? If the employee's leave is approved, the department will send a notice to both the employer and the employee. This notice will include the reason for the approved benefits, duration of the approved benefits, frequency and duration if it's for intermittent leave, expiration of approved benefits, and the weekly benefit amount. The department will begin benefit payments within 14 calendar days of approving the leave, or as soon as eligibility begins if the leave is approved more than 14 days before the employee is eligible for leave. And what if the leave is denied? If the leave is denied, the department will provide a notice to both the employee and the employer. This notice will include the reason for the denial and a description of the employee's appeal rights. If the employee would like to appeal the denial, the request must be filed within 10 calendar days after receiving the denial notice. The employee may also request a hearing. The department will issue a final decision within 30 days of the hearing. The employee can take a further appeal by filing a complaint in the district court of the county in Massachusetts in which the employee resides or is employed. The employee must do so within 30 calendar days of when the employee receives the state's final decision. Some employees may need an amendment or extension of their leave. If there is a change in circumstance that would justify an extension or reduction or any other change in benefits, the employee must notify the state within 7 calendar days of that change. If an extension is needed, the employee must file the request within 14 calendar days of the expiration of their original approved leave. The employee will need to notify the department of the reason for the extension, the requested duration of the extension, the date in which the employee notified the employer of the need for an extension, and a new and updated certification. The state will notify the employer of this request no more than 5 calendar days after it is received. The state will then notify the employer of the requested duration of the extension and whether it is continuous or intermittent, and provide any additional certifications to support the leave. The employer must provide any requested information to the department within 10 business days. This information will include if the employee will receive any paid benefits during the extended leave period, and if the employer has approved or will approve to extend the employee's Pfml leave or other policy. I do also want to note that the 7-day waiting period does not apply for an extension of benefits. Employers may have a policy that requires all employees who take medical leave to present certification from their healthcare provider that the employee is able to return to work. In order to require a fitness for duty certification, employers must provide the employee with a list of their essential job functions within 10 business days of receiving the notice that the leave has been approved. Also, indicate that the certification must address the employee's ability to perform those essential job functions. An employer can only seek the certification for the specific health condition that causes the employee's need for leave. It must certify that the employee is able to return to work and the employer can require it to specifically address the ability to perform the essential functions of the job. An employer may delay the employee's return to work until this certification is received. Employers may not request a certification of each absence taken on an intermittent or reduced schedule. If you joined us for the Mass Pfml webinar we did last year, this information may look familiar to you. As a quick recap, the employee's rights under the law include job protection, benefit protection, and anti-retaliation. Unlike many other state paid family and medical leave laws, Massachusetts paid family leave does include job protection. An employee must be restored to their same or equivalent position when they return from leave. They still have the right to accrue vacation time, sick leave, and bonuses. One piece of the job protection I do want to mention: an employer is not required to restore the employee if other employees of equal length of service, credit, and in same or equivalent position have been laid off due to economic conditions or changes in operating conditions. Just something to remember as we are still dealing with the COVID-19 pandemic. Employers are also required to continue employees' health benefits under the same conditions provided the employee had not taken leave. The employer must also continue to make health insurance contributions as if the employee had continued working. The employee is still responsible for paying their share of the premium. Employers are prohibited from retaliating against employees for taking leave or exercising their rights under the law. Presumption of retaliation is if there is any negative change in seniority, status, employment benefits, pay, or other terms and conditions during the employee's leave or 6 months following the return. Thanks everyone for joining us today. I hope that this answered some of your questions about Mass Pfml and how the state plans to administer it. We have put together a Mass Pfml public option guide that will go into further detail about what we talked about today. That will be included in the follow-up communications along with the full question and answer, as well as a recording of the webinar. All right, let's get into some questions. All right, thanks for submitting all of your really detailed questions. We appreciate it. Let's get started. What if an employee has 2 employers? So an employee with multiple employers is not required to take leave from every employer during a single leave period. At this time, the regulations do not state that an employee covered under a private plan and a public plan through another employer could not file an application for both plans and receive a benefit under the both of those plans. So potentially more to come on that, but at this time, they could potentially take leave from one employer or both employers. What if an employee has a baby in 2020? Are they entitled to baby bonding leave in 2021 under Mass Pfml? Yes, the baby bonding leave is available within 12 months of the birth, placement, or adoption of a child. So employees who welcomed a child in early 2020 would not get the full 12-week benefit, but most employees would be eligible for the 12 weeks of baby bonding leave, especially if that child was welcomed towards the end of 2020. There is no look back period during the first year, so any previous baby bonding time or FMLA leave that was taken would not affect the eligibility for the leave in 2021. The state has also indicated that employees can begin applying for baby bonding leave through the state beginning early December of this year to be prepared for 2021. Is a substance abuse disorder considered a serious health condition? Yes, but family and medical leave can only be taken for treatment of a substance abuse disorder if it's by a healthcare provider, a provider of healthcare services on referral by a healthcare provider, or a program approved by the Mass Department of Public Health. That leave is not available for the use of a substance rather than treatment. So the employee or the family member would need to be receiving treatment for that substance abuse disorder. What did you mean when you said family leave can be taken intermittently to bond with the child only if the employer and employee agree? Employers are not required to offer intermittent leave for baby bonding, but they will need to develop a policy as to whether they will permit that. They will then need to administer that policy the same way for all of their employees. If an employee has a baby, will the medical leave run concurrently with the family leave the way it does with FMLA? If an employee has a baby, the medical leave and the family leave will run sequentially, not concurrently. This is the one situation in which the waiting period does not apply, as long as the employee takes the medical leave immediately following the baby bonding leave. The maximum benefit for the medical and family leave is the combined 26 weeks. How will Mass Pfml benefits coordinate with the short-term disability benefits? Short-term disability benefits will be offset by the actual or expected benefit received from Mass Pfml in situations where the employee is eligible for both of those benefits. So the employee's Mass Pfml benefit would be calculated and paid, and the STD plan would offset for that amount and pay the remaining amount up to the maximum on the STD policy. If the payment received from the state meets or exceeds the maximum STD payout, no STD payments would be made. What checks are there to prevent an employee from double dipping by applying for leave through a private plan as well as the state plan? If an employee were to apply to the state for a benefit, the state would review its records and discover that that employer has a private plan and that no contributions or earnings have been reported or sent to the department on behalf of that employee. So the state would deny that employee's application for benefits. What is the reimbursement claims process? The state has not yet outlined the process for submitting reimbursement. We expect that that will include a requirement to document that the employee was paid from a reimbursement eligible employer-sponsored paid program, such as a parental leave policy, and that the employee was not paid by the employer's private Pfml policy or accrued PTO. How much would we be reimbursed? As a reminder, no reimbursement would be made to an employer who has an exemption from the department for a private plan. If your organization provides benefits to an employee that is equal or greater than the benefits from the department, then you could be reimbursed by the department up to the amount that the department would have paid out to the employee. What if an employee files a claim with the state instead of with us or our private plan? Again, the state would see that that employer has a private plan exemption and the employee would not be enrolled in the state plan. The state would deny that claim, sending a denial notice to the employee and the employer. What if a newly hired employee requests leave but has not met the eligibility with us yet? How are we able to check on past employment? Employers that have a private plan exemption may require an employee to provide verification of wages earned with an employer in Massachusetts in order to determine whether that employee meets the financial eligibility requirements. How does the employee taking PTO during the 7-day waiting period impact the start of the Pfml payment, if at all? Using PTO during the 7-day wait period wouldn't impact the start of the payment, as no payment would be issued by the state during those first 7 days. Can PTO be used by the employee during the waiting period? Yes, employees are able to use PTO during the 7-day waiting period. If an employee chooses to take baby bonding leave later and not immediately following the medical leave, would the 7-day waiting period apply? Yes, the 7-day waiting period would apply if the baby bonding leave doesn't immediately follow the medical leave. I think that might be, oh no, we do have some more. Where Okay, if I have both a company paid STD benefit and private Pfml insurance, how do they work together?
which pays first and how much is paid to the approved eligible employee. So the PFML insurance should pay first. That would be calculated by, if it's a private plan, calculated by the carrier. The eligible employee would get their standard benefit from the PFML, and then the STD benefit would pay the remainder up to the STD maximum. Can you describe how leave works for male versus female and birth of a child? So the female would be eligible for the medical leave as well as the baby bonding leave. Again, the 7-day wait period wouldn't apply if they take the medical leave immediately followed by the baby bonding leave, but they do still have that 26-week maximum. And then for the male, they would again be eligible for the 12 weeks of baby bonding leave. Is there a reason to keep an STD policy if PFML covers similar leave? Yes, so there could be situations where an employee would need an STD policy, potentially not covered under PFML, and it also could leave some employees not eligible for a benefit if you were to get rid of an STD policy, and there is the potential that it could provide an additional benefit on top of the mass PFML. What is the certification form that the employee needs to provide when they fill out the application? So the state has not provided the certification forms or the application forms yet, but hopefully soon they will be releasing the certification forms that will need to be filled out for the leaves to be filled out by the doctor, certifying that the employee needs to be off of work for either their medical or their family leave. Okay, I think we were able to get to as many questions as we were able to today, but the full question and answer will be going out in the follow-up email with a recording of the webinar. There were a couple of questions received that do require some further research, some that are pretty specific as well. We want to make sure we get the best answers from you, for you, from the state. So we'll reach out to those people individually and include those responses in our follow-up as well. All right, thank you everyone.